everybody. Welcome to the Innovation Game, the podcast by the intellectual property law firm Potter Clarkson. My name's Rich Wells. I'm a senior associate patent attorney in the life sciences department, and I'm joined today by Tony Proctor. Tony, I'll let you introduce yourself.
Thanks, Rich. As you say, I'm Tony Proctor. I'm a partner at Potter Clarkson, patent attorney, and also working in the life science department at the firm.
Great. So, how are you, Tony? What have you been up to recently?
It's been a busy time recently. So we've just finished handling a case in the UK Court of Appeal. Really interesting to work on because it was a remote hearing, which is quite unusual in UK court litigation to have a remote hearing. But this hearing was conducted over Teams with the judges all on their own screen and barristers dialing in as well, and really interesting to see. It worked really well, actually. It was a good experience. So it shows that we are finding new ways to work, and it's great to be part of these new innovations.
Oh, it sounds great. I can imagine court of appeal hearings are sort of nerve-wracking enough, let alone sort of worrying whether your Wi-Fi is going to hold up to it. But it sounds like everything went well anyway.
It's interesting, yeah. I mean, the first instance hearing at the Court of Appeal lasted about 3 weeks, and then at the High Court lasted about 3 weeks, and then you get to the Court of Appeal, and it all gets condensed into 3 days. So it's quite an intense process. But as I say, it's a great experience, and we're just waiting to hear the decision now.
Oh, fingers crossed, fingers crossed. So what we're going to talk about today is trade secrets. So let's kick off with, well, what is a trade secret, and what kind of businesses do trade secrets kind of apply to?
It's really interesting. I think trade secrets is one of these IP terms that most people have a vague idea about what it relates to. It gets bandied around a lot. Businesses will talk about their technology being a trade secret, but often without having a full understanding of what it actually means. I mean, the basic criteria of firstly, it has to be something that's secret, something that's confidential to your business. Secondly, it has to have value of some kind, and it can be value now or it can be predicted value in the future, but it has to have some value to your business at some point. And then thirdly, and this is a relatively new way of thinking about it, it has to be subject to reasonable protection measures. And that's a requirement to essentially, if you are asserting that you have a trade secret, you now need to demonstrate that trade secret was subject to some reasonable protection measures.
Okay, and I suppose some notable examples are things like, Coca-Cola, WD-40. Yeah. But I suppose they do apply to sort of a broader range of businesses than just sort of these kind of almost household names that everyone kind of sort of associates with trade secrets. That's
absolutely, that's the kind of classic thing that people would think about when they think about trade secrets, would be these kind of recipes almost. The Coca-Cola recipe, the recipe for Kentucky Fried Chicken, etc. Probably the trade secrets that people will encounter most in their daily lives will be software-based trade secrets. So things like the Google search algorithm that determines the way that hits are presented when you do a Google search. That's a trade secret, and that's something that again we'll all encounter in our daily lives. It can also go beyond that, though, and into areas that companies wouldn't necessarily think of as being trade secrets. So, for example, information relating to the way that a particular machine is calibrated, or the way that the raw materials for a particular process are ordered, and the timing of those orders and way in which the materials are stored. Or even market intelligence, so things like analysis of customer spending habits across different territories that will have value to the business because it will affect the way that the business deploys resources, and that value can give the business a competitive edge over others working in the same area. So worth protecting, worth securing, and essentially if time and effort has gone into generating this information and it's valuable to the business, then it could be a trade secret.
And I think that's really interesting, because I think what I get from that is that trade secrets can touch every part of a business, from something that's a product that's sold to a consumer to something that kind of happens behind the scenes. And I suppose the way that I view them is it's something that should be integrated just into your general strategy of thinking, about IP alongside patents and alongside, trademarks, depending on necessarily where your business's value lies. And I guess, based on that, you've said that they've got to be valuable, but what value do you think that they bring to a business? Because it's slightly less, maybe less tangible than, say, a patent, sort of a right that's maybe officially registered at a patent office, say.
Well, they can be just as valuable. And I think it's interesting to stack the trade secret up against the patent and to see kind of where the pros and cons lie. Because as you say, with a patent, you have a registered right, you have a way to stop anybody from using that particular process or that particular product, regardless of where they got the information from. But you also have a limited right in the sense that it can be challenged, the validity can be challenged in court of that patent, and it will expire after 20 years in most territories. So another option, the trade secret option, to compare that with patents, if you are able to keep the information as a trade secret, then potentially the lifetime of that protection can be infinite. As long as you can keep it secret, as long as you can keep it protected, then your competitors are not able to access that information. The downside of keeping it as a trade secret has always been the risk, however, that the information would leak out from the business, and that risk has increased, I think, as we've moved into the modern era, where maybe 50, 60 years ago, the recipe for Coca-Cola was kept in a safe, and as long as nobody was able to break into that safe, you were okay. Now information is shared across multiple sites, shared in a digital format, and so risks associated with computer hacking, unauthorized access of the information have increased. And also people move around. So people who've had that access to that information within your business might move to a different company and have that information is known to them, maybe even taken with them on a USB stick. And so these kind of risks have increased. And I think the good thing is that the law has caught up with this, recognized this, and put in place some strong protections around trade secrets to make them a really viable IP option.
So, yeah, you talk about, obviously the kind of COVID world in which we are working in now, which, in some form, I think will carry on with people working from home, working from remotely. Are there any other reasons why we're talking about this, now? What are these sort of changes in law and how the world's changing, that's kind of bringing trade secrets maybe more to the front as kind of what should be a really integral part of any kind of IP strategy?
I think you're right. I think it's the changes in the law that have really brought this front and center. And so we had in 2018 the European Trade Secret Directive. Got a little bit lost at the time because it came around about the same time as GDPR, and of course GDPR sent everybody into a bit of a tailspin. And now that businesses have recovered from that trauma, I think they've rightly moved on to look at the other legislation, such as trade secret provisions. And that was matched a few years earlier, in fact, in the US with the US Defend Trade Secrets Act, and then similar legislation in other industrialized nations such as Japan, China. The purpose of which is to set out a legal framework whereby if you subject your trade secrets to reasonable protection measures, and this is wording that's common to all of these new pieces of legislation, if you can show that you've put in place reasonable protection measures, should that trade secret be misappropriated, so stolen by a third party, and you can prove that, then there are some pretty strong protection measures that you can take to take action against the party benefiting from the theft of that trade secret, or the party that perpetrated the theft of that trade secret. And certainly we've seen a big rise in US litigation over the last few years, where these trade secret theft cases have been brought in the US courts, and the damages awarded are often in the hundreds of millions of dollars. So some pretty serious consequences.
Yeah, this is definitely serious, from both sides, both as, someone who has trade secrets and someone who maybe doesn't want to step on anyone else's trade secret. So with that in mind, we're living in a changing world, as you say, and you've talked about sort of these reasonable steps that companies need to take in order to sort of establish they've got a a trade secret. So from a practical perspective, first thinking about, a company, a business, an individual that has trade secrets, what can you do in order to give yourself the best position?
I think there are two things really. I think there's understanding the value of trade secrets to your business, and ensuring that your employees and your team understand what a trade secret is and why it's important. So there's an education aspect to it, and that's something that really falls into, I guess, a big picture education program where the R&D departments within a business need to be aware of different types of IP, but also the business as a whole needs to be aware of the value of IP to the business. And trade secrets are an important component of that. So having a trade secret education program within your business, accessible by all employees to raise their awareness, I think is one thing that's quite important. The second thing, I think, is having a good understanding of where your business is at the moment in terms of how it manages its trade secrets. So how it identifies trade secrets, how it categorizes the importance of those trade secrets, what measures it has in place to protect those trade secrets, and how it deals with trade secrets in its interactions with third parties. So, for example, with a supplier or with a research partner, how the transfer of that information is managed and how trade secrets are identified there. And really stacking that up against where that business maybe could and should be in terms of its management of trade secrets in order to better comply with the legislation, and building really a pathway for it to understand how the business as a whole can improve and put better protection measures in place.
I quite like this as kind of like a theory about how businesses should set themselves up, because a lot of that is maybe what innovator businesses in particular are doing or should be doing in relation to what they'd see more classically as like the patent types of IP, and how these inventions are identified and protected if that's deemed to be necessary. You either can work the sort of trade secret education in there to your researchers, your R&D department, or if you don't have that kind of education, then I think probably the whole firm can benefit from just upping that game, as it were. And sort of turning it on its head, you've said that especially in the US, the penalties for infringing, if it's proven someone else's trade secrets, are pretty steep. There's almost a defensive element to that. How can a firm try and establish that they stop their employees from inadvertently, or maybe purposefully using trade secrets, especially with the amount that people move around between firms nowadays?
Yeah, it's a really good point, and I think this ties into the education aspect as well, because the first risk to a business is that an employee will leave, go to one of your competitors perhaps, and take information with them that's a trade secret. I think making sure that they are aware of the fact that the information they're dealing with is a trade secret, they're aware of the law and the quite serious consequences in terms of any misappropriation of trade secrets, and certainly at the point when they leave the business, that they're reminded of these points and reminded of their obligations. I think that's certainly a measure that businesses can put in place to try and reduce the risk of trade secrets leaking out of the business. But as you say, there's another risk as well, which is when you're hiring somebody who might have been working for one of your competitors. It's natural for a new employee to want to impress with at a new employer. Their first few months on the job, they want to show that they're bringing value, and these kind of new ideas, new thoughts that they might bring into the business. There's a risk that information is a trade secret that they've brought with them from their previous employer. So that again, looking at employees coming in the other direction at the point when they join the business, when they have that kind of onboarding with the business, that part of their education and training at that point is to make them aware of the fact that the trade secrets are important to the business. Your company is a company that respects third-party trade secrets, and that it has a clear policy in relation to how it handles trade secrets. That can reduce the risk of a trade secret being brought into the business, and also can certainly serve as a defense if a business is accused of misappropriating a trade secret, to be able to say, well, we took all measures we possibly could to make sure we were not on the receiving end of any trade secrets. And if this did happen, then it was the actions of a rogue employee that we tried to safeguard against, and can certainly help as a defence against the misappropriation, but also certainly help as a defence against some of these quite steep awards of damages that we've seen in the courts.
No, that makes sense. So no, thanks for that, Tony. I think that was a really good introduction and some really good practical points on what is quite a complex area of IP law. So, just to summarize, what are your 3 take-home messages from trade secrets that people should try and keep in mind if they're kind of considering it as an issue?
Yeah, I mean, firstly, I would say if you're wondering whether your business has trade secrets, I would say you probably do, and whether you realize it or not. Some businesses will have trade secrets kind of front and center of their thinking. Some businesses won't think about trade secrets at all, but chances are you do have trade secrets. Secondly, knowing that you have trade secrets, you need to think about how you're managing those trade secrets, and it's important to have an understanding of where you are at the moment, and what structures you have in place, what procedures you have in place. And thirdly, moving on from that, it's important to have an idea about where you want to be as a business, so where you can go to improve your management of trade secrets, and the steps that you can take to get there. I think that building that understanding into your business plan, it's not something that a business can change overnight. It's a process. It's a path that to go on. But I think at least identifying the value to be had in better trade secret management, and identifying the steps you can take, some of which could be very small, some of which could be only very, very minor changes to the way that the business operates, but could have a huge impact. I think that thought process is something that's going to be very valuable for most businesses.
I know, that's great. So should just mention at this point that Potter Clarkson have a new product called Safeguard, which is essentially a auditing tool where we will come into your business and we will help you understand where your trade secrets may be, and help almost put the practical steps that Tony mentioned of how they could be catalogued, and how the education of employees about trade secrets can kind of be integrated into your firm's work process. I know, Tony, you've had a lot to do with putting this product together. Is there anything else you want to add about it? Or
yeah, I mean, we recognise that trade secrets is something that IP firms have historically been quite bad at helping their clients to deal with. The conversation, traditionally would be, well, you can either file a patent application or you can keep it as a trade secret. And if you're going to keep this as a trade secret, then it's up to you really to do that, to keep it secret. But now, with the new laws coming into place, the new provisions around reasonable protections, we really want to help our clients get better at managing their trade secrets. And so, as you say, Safeguard is a new service that we've developed, really aimed at just that, helping our clients improve their compliance with trade secret laws and put them in a better position to protect and manage their trade secrets. So we're hoping people will like it. we welcome any feedback, and we look forward to working with businesses on their trade secret journey.
That's great, and it can be found at our website, www.potterclarkson.com. This podcast, previous podcasts, and future podcasts can all be found on SoundCloud, Spotify, YouTube, and all that leaves me to do is to thank you, Tony, for your time, and I thought that was really interesting, and it's a really good chat.
Thanks, Rich. Nice talking to you.
Yeah, thank you, and thanks to everyone for listening. Take care.